Sacked members of the Rivers State Civil Service Commission don drag the Sole Administrator to court. Welcome country people to Synok Media. Abeg, if you never subscribe to our channel, make you do so now. Make you put on the notification button. E go give you notice once we drop updates. Make you like, comment and share our videos. Country people, una go recall say on March 18, President Bola Tinubu make announcement where he announced the state of emergency rule for Rivers State. And for that announcement, he come appoint sole administrator for the state. And the sole administrator when he appoint na retired Vice Admiral Ibok Ete-Ibas to govern the state for the first 6 months. That action of the president e come cause uproar, and e still dey cause uproar as plenty people dey sad and dey angry too that the president no get the power to do that kind of action, although the president action later come get validation by the National Assembly. Stakeholders for Rivers State and other Nigerians say the action dey wrong. As dem dey talk that one, the sole administrator Ibok come drop all the appointees of Fubara government. Start with the SSG, head of service, he come replace them. He come enter boards. He come enter all statutory boards and non-statutory boards. He drop all of them. He enter local government. He drop all of them. This action come dey make people dey wonder that this na person when he dey 6 months program. He dey do as if he want to stay forever. Many people don go court to see how they go fit reverse the state of emergency rule. But this time around, na the people when he sack na come take am go court. And na the chairman and members of the Rivers State Civil Service Commission when the suspended governor Siminalayi Fubara appoint na don drag the sole administrator Ibok Ete-Ibas to court over their suspension. The claimants, Reverend Godlife Idoko Ben, Amadi Christian Echele, Chimenim Wisdom Jerome and 3 others, dey challenge wetin they describe as their illegal removal by the sole administrator. That they talk say they appoint them lawfully, and also they confirm their appointment that na the Rivers State House of Assembly na do that one, and the governor come issue them letters of appointment, and records of their confirmation e dey with the clerk of the house. And because na statutory board, they get their tenure. Their appointment dey tenured. E no dey subject to the whims and the caprices of any government. That is why once you appoint them, they must serve out their time. So for the affidavit when they sign, the suspended chairman Ben and the claimants them, they insist say the sole administrator e no get the legal power to suspend them and come appoint new chairman and members for the commission. The report when he enter, he say the matter come up for hearing on Thursday, and the legal team of the sole administrator e make up of 5 senior advocates of Nigeria. They filed their defense along with a notice of preliminary objection where they challenge the jurisdiction of the Rivers State High Court to hear and determine the matter. The claimants dem still dey tok say by the combined provisions of the Emergency Powers Act 1961 and the Emergency Powers Jurisdiction Act 1962, the proper court for such matter na the Federal Supreme Court, and dem dey argue say since dis thing don dey modified by regulation of the president to what is now known as the Supreme Court of Nigeria, the legal team of the state sole administrator e dey rely heavily on the legislations wey dem don talk to take argue. For their defence, dem dey say the sole administrator im derive im power to suspend and make appointment from those laws. Although the claimants legal team for their response dem dey insist that both the 1961 and 1962 acts rely upon by the defence say dem dey obsolete. Dem dey state say under the 1999 constitution of the Federal Republic of Nigeria, e say those laws dem don dey spent, and so dem no get effect as such. The presiding judge, Justice Frank Onyiri, e come adjourn the case to the 17th of June 2025 make e for adopt all the processes. Country pipo, una don see the tricky situation wey e don dey play up for Rivers State, and this situation e be like litmus test, because once these people succeed for their quest, there go be plenty of such cases wey e go come up to come challenge the powers of the sole administrator to suspend them. So this one, the legal team for the sole administrator need to prepare to up their game, because if one of these cases win, then I be say the rest go follow suit. However, one question we wan ask ourselves, where they declare state of emergency, that emergency rule e no suppose to cancel the order when e dey the system, abi the order when e dey the system go still dey on even when they get emergency rule. All the lawyers in the house and all those wey dey understand the constitution properly, una go educate us, because if the two groups now for court dey argue, one say e derive the powers from this place to suspend them, another group of lawyers dey say the law wey dem dey hold on to so e dey obsolete, which one we go come believe say na be the true situation? Well, that na why every court get judge, and the courts dem not dey moved by sentiment or emotions. Na the fact of the matter na go speak. How una see this development?